to the lecture series on employee relations and labor laws. Today we will discuss about the Payment of Wages Act 1936. I am Dr. Kokila Saxena from JSS Academy of Technical Education, Noida. To introduce this act, we can say the desirability of legislative enactment to protect the wages earned by the workers while working in factories and other establishments. The Royal Commission in India in 1934 examined the entire question in detail and recommended the legislation regarding wages, mode and manner of payment, deductions from wages and imposition of fines in certain cases. The object of the act is to provide the employed persons shall be paid wages in a particular form and at regular intervals and without any unauthorized deductions. So, we will discuss various authorized deductions also which can be imposed on the employees. Now, we will start with the important definition part, which is section 2. Definition part consists, first is appropriate government, means in relation to railways, air transport services, mines and oil fields, the central government, and in relation to all other cases, the state government will be the appropriate government. Now, next is employed person, includes the legal representatives of a deceased employed person. Employer includes the legal representative of a deceased employer. Next important definition in this act is factory, which means and include any place to which the provisions of the act have been applied under subsection 1 of section 85 thereof. Industrial or other establishment means any tramway service or motor transport service engaged in carrying passengers or goods or both by road for hire or reward. Next is air transport service other than such services belonging to or exclusively employed in the military, naval or air forces of the Union or the civil aviation department of the Government of India. Other than these, dock, wharf or jetty, inland vessel mechanically propelled, mine, quarry or oil field, plantation. Next is workshop or other establishment in which articles are produced, adapted or manufactured with a view to their use, transport or sale. Next subsection, establishment in which any work relating to construction, development or maintenance of buildings, roads, bridges or canals or relating to operations connected with navigation, irrigation or the supply of water or relating to the generation, transmission and distribution of electricity or any other form of power being carried on. Next in this includes any other establishment or class of establishments which the central government or a state government may, having regard to the nature thereof, the need of protection of persons employed therein and other relevant circumstances, specify by notification in the official gazette. Mine has the meaning assigned to it in clause J of subsection. Next is next definition is wages. Wages means all remuneration, whether by way of salary, allowances or otherwise expressed in terms of money or capable of being so expressed, which would, if the terms of employment express or implied were fulfilled, be payable to a person employed in respect of his employment or of work done in such employment, and includes number 1, any remuneration payable under any award or settlement between the parties or order of a court. Second, any remuneration to which the person employed is entitled in respect of overtime work or holidays or any leave period. Next, any additional remuneration payable under the terms of employment whether called a bonus or by any other name. Next is any sum which by reason of the termination of employment of the person employed is payable under any law, contract or instrument which provides for the payment of such sum, whether with or without deductions, but does not provide for the time within which the payment is to be made. Next, any sum to which the person employed is entitled under any scheme framed under any law for the time being in force. All these things are included in wages, but certain things are specified in the act which are not included in the wages, and these items are: number 1, any bonus whether under a scheme of profit sharing or otherwise which does not form part of the remuneration payable under terms of employment, or which is not payable under any award or settlement between the parties or order of a court. Next is the value of any house accommodation or of the supply of light, water, medical attendance or any other amenity or any services. These are excluded from the computation of wages by a general or special order of the appropriate government. Next is any contribution paid by the employer to any pension or provident fund and the interest which may have accrued thereon, any travel allowance or the value of any travelling concessions. Next is any sum paid to the employed person to defray special expenses entitled on him by the nature of his employment, or any gratuity payable on the termination of employment in cases other than those specified in subclause D. Now comes the provisions of the act. The first provision contains in section 3, which says about the responsibility of payment of wages. Now, this provision says that every employer shall be responsible for the payment of all wages required to be paid under this act to persons employed by him, and in case of persons employed in factories, if a person has been named as manager of the factory under the subsection 1 of section 7 of the Factories Act 1948. Also, in industrial or other establishments, if there is a person responsible to the employer for the supervision and control of the industrial or other establishments. In railways, if the employer is the railway administration and the railway administration has nominated a person in his behalf for the local area concerned. In case of contractor, a person designated by such contractor who is directly under his charge, and in any other case a person designated by the employer, the person so nominated or the person so designated as a case may be, shall be responsible for such payment. The person so named and the person so responsible to the employer or the person so nominated as the case may be will be responsible for such payments. It is also provided that anything contained in subsection 1, it shall be made responsible of the employer to make payment of all wages required to be made under this act in case the contractor or the person designated by the employer fails to make such payments. Next is fixation of wage period, which is section 4. It is provided that period of wage payment should be fixed, period shall not exceed 1 month of time. Next is section 5, which talks about the time for wage payment, which says that any factory or industrial establishment in which less than 1000 persons are employed, wages must be paid before the expiry of the 7th working day after the last day of the wage period in respect of which the wages are payable, and in all other cases wages must be paid before the expiry of the 10th day of the month. Where the employment of any person is terminated by or on behalf of the employer, the wages earned by him shall be paid before the expiry of second working day from the day on which his employment is terminated, and all payments must be made on a working day. Next is section 6, mode of payment of wages. The provision says that all the wages shall be paid in current coin or currency notes or in both. However, the Act provides that the employer, after obtaining a written authorization from employee, can pay either by check or by crediting in bank account. Next is authorized deductions. These are authorized deductions from wages. These are section 7 to 13. Authorized deductions are any loss of wages resulting from the imposition of the penalties are termed as authorized deductions. A withholding of increment or promotion, including the stoppage of increment at an efficiency bar, the demotion or time scale or a longer stage in scale, or suspension. These now we will talk about various provisions which are allowed as deductions, or we can say these are authorized deductions which are permitted from the wages of the worker. Now, this is provided in the Act that wages of an employed person shall be paid to him without deductions of any kind except those authorized by or under this Act. Every payment made by the employed person to the employer or his agent shall, for the purposes of this Act, be deemed to be a deduction from wages. Second, any loss of wages resulting from the imposition of good and sufficient cause upon a person employed of any of the following penalties, namely the withholding of increment or promotion, the reduction to a lower post or time scale or to a lower stage in a time scale, or suspension, shall not be deemed to be the deduction from wages in any case, where the rules framed by employer of the imposition of such penalty are in conformity with the requirements, if any, which may be specified in this behalf by the state government by notification in the official gazettes. Deductions from the wages of an employed person shall be made only in accordance with the provisions of this Act and may be of the following kinds. Now, first deduction which can be made from the wages of worker is fines. According to section 7 subsection 2a of the said Act authorizes deductions by way of fines. Section 8 lays down the rules for the imposition of such fines. Section 8 says that no fine shall be imposed on employed person in respect of such act and omission on his part as an employee has specified and the employee has specified by notice. Now, various provisions of fines are number 1 is notice leading of fines on workers out to be shown in the work premises. Second is fine out not to be forced on the worker until he gives the clarification and causes of the demonstration or omission he made. The aggregate sum of fine out not surpass 3% of his pay. Fine out not to be forced on any representative who is younger than 15 years. Fine out to be forced for one time just on the pay of the employee for the demonstration or exclusion he made. Fines out not to be recovered in the method for portions or payments from the representative. Fine out to be recovered within 60 days from the date on which fine was forced. fine ought to be forced on the day act of exclusion made by the worker or the employee. All fines granted from the worker ought to be credited to basic reserve and used to help the employees. Now, next is deductions for absence from duty. Section 7 2b of the Act permits deductions for absence from duty. The authorizes the employer to make deduction for absence from duty. Such a deduction can be made only on account of the absence of an employed person from the place of work, where according to terms of employment he is to be present. If he, though present in person, refuse to carry out his work in pursuance of a stay, in strike or any other cause which is not reasonable in the circumstances. Similarly, tool down strike without any just cause amounts to absence from duty. Next is deductions for damages or loss of goods. The Act also authorizes the employer to effect deductions for damages to or loss of goods according to section 2c. If any money or goods entrusted to the employee is lost by his negligence or default, the employer is entitled to deduct such loss. Next deduction is deductions for services rendered. According to section 7d, the Act authorizes the employer to make deductions for house accommodation supplied by the government or any housing board set up under any law for the time being in force, whether the government or the board is employer or not, or any other authority engaged in the business of subsidizing house accommodation, which may be specified in this behalf by the state government or appropriate government by notification in the official gazette. Next is deductions for amenities and services. Section 2e, the deductions may also be made for such amenities and services supplied by the employer as the state government or the authorized person in this behalf authorities the employer to provide amenities or services. The word services for the above purpose does not include the supply of tools and raw materials required for the purpose of employment. Now, next is deduction for recovery of advances. Section 7f authorizes the employer to make deductions for the advances made by him, which includes advances for travelling allowances or convenience allowances. Next is deductions for recovery of loans. Section 2ff, the employer may make deduction for the recovery of loans together with interest made from any fund constituted for the welfare of labour in accordance with the rules approved by the appropriate government in this regard. Next is deductions for recovery of loans granted for house building. In this provision, it is provided that the deductions are also permitted to be made for the recovery of loans and interest granted for house building or other purposes in accordance with the rules approved by the state government. Next is deductions for recovery of deductions for income tax payable by employed person. If employed person is liable for any income tax to be paid, that deduction can be made from his wages. Next is orders of the court. If there is any settlement process went in court and court has decided to get the wages deducted from the workers, wages, that deduction can be made. Apart from these, any contribution to provident fund, payment to cooperative societies and insurance schemes, for house accommodation, or acceptance of counterfeit based coins, if it is been made by the worker, all these deductions can be made from the wages of the worker. Now, next deduction is deduction for recovery of losses on account of failure to invoice or to collect. Deduction for incorrect rebates or refunds. If any incorrect rebate or refund has been made to the employee or the worker, that deduction can be made from the wages of the worker. Also, if he had collected wrongly or he had made an invoice of wrong amount, that deduction can also be done from the wages of the worker. All deductions which are legal in nature, they can be made from the wages of the workers. Now, we will discuss about what illegal deductions are. All deductions for damages or loss is not attributable to his neglect or fault. If any damage or loss is not done is done without any negligence or fault of the employee or worker, and even then wages have been deducted, that is called illegal deduction. Next is deduction from railway administration on account of any rebate, refund incorrectly granted, and such loss is not directly attributed to the neglect or default of an employed person. Next is deduction made for payment of any insurance policy without written authorization of employed person. If there is any deduction made by the employer from the wages of the worker, and it is due for any insurance policy, but worker has not given in writing to the worker to the employer, and he did it, that will be deemed as illegal deduction. Deductions are made wholly or partly made for payment of to cooperative societies exceeding 75%. If the deduction is made for the payment of cooperative societies and it is the deduction is exceeding 75%, that deduction will be deemed as illegal deduction. And in any other cases, if it exceeds 50% of his wages, that will be deemed as illegal deduction. Now, there is a provision regarding the maintenance of registers and records in the organization by the employer, which comes under section 13A, which says that every employer is required to maintain the register in following matters. First of all, he should maintain the details of people employed, workers employed in the organization, then the nature of their work, what they are performing in the organization, what are the wages they are being paid, what are the deductions he is making from the wages of the workers, also other particulars which are required by the authorities or which may be prescribed by the authorities should be maintained within the organization by the employer. These registers and records must be preserved for 3 years and must be available at the time of inspection. Now comes the authorities under the Act. Basically, under Payment of Wages Act, inspectors are appointed by the appropriate government. This is under section 14, and they are appointed for the purpose of this act within the local limits. The inspectors are empowered to make examination or inquiry in order to ascertain the provisions of the act. If there is any prohibition of any act or there is any illegal deduction made, so in that case he can examine any paper or he can inquire any person within the organization related to Payment of Wages Act. Also, inspectors can enter, inspect and search any premises of any factory or industrial establishment at any reasonable time for carrying out the objective of the acts. Also, inspectors can supervise the payment of wages to employed persons. Means he can personally go to the organization and can supervise the payment of wages as and when the payments are being made. Also, inspectors can seize or take copies of registers or documents if they feel to get it done. They can also take the copies of all the documents, whatever they think, whatever they feel suitable for the process. Also, they can exercise such powers as may be prescribed in the act or as given by the appropriate government. In this act we have gone through various provisions of we have studied various industrial establishments, what industrial establishments are coming under this act, and we studied what are wages, what things are included in wages and what are not included in wages. We have gone through all these provisions, and then we have studied all provisions related to responsibility and time, fixation of wages, mode of payment and deductions, and all the provisions related to fines and all deductions made which can be made from the wages of the workers. And then we have studied about various maintenance of registers and records, as well as we have gone through various authorities under the act which have powers to take care of the industrial establishments, and they are responsible to regulate or to exercise the laws pertaining to the industries. Thank you all. This is all about Payment of Wages Act. Thank you so much.